back to the show. This is The Law Show on CL 650.
That's the power of love.
Hey, and welcome back to the show. You're listening to The Law Show on CL 650. Joining me in studio, Alyssa Lockhart, partner at McQuarrie Hunter, and Leah Donaldson, associate at McQuarrie Hunter in the Will and Estates Division, I guess, is that what you call it? Yeah. Department. There you go. Now, on the previous show, we talked about WESA, and you're going to describe a little bit about what that is and what's called undue influence. So I've heard this talked about because WESA came in 2014. So describe what WESA is and how undue influence can be a problem.
So the Wills, Estates, Succession Act, which we refer to as WESA, did come in 2014. It replaced several very old statutes that had been updated and modified, but really didn't form a comprehensive estate planning and estate administration package as far as our legislation went. So it's a statute that covers a number of different areas. The question that comes up with undue influence is generally we'll see one child perhaps taking good care of mom or dad during their waning years. Other children are precluded from that, maybe because they live far away or because there's a rift in the relationship. Does that child receive a gift in mom and dad's will because mom and dad felt they had given up time in their own life or lost opportunities in their own life due to the care that they're providing? Or does that child receive extra gifts in the will because they had unduly influenced mom and dad? That's
a real gray area, though, isn't it?
It can be, you know.
So if you're the child that lives closest to mom and dad and you're in and out of the house all the time looking after them, the parents might say, well, you're spending the last 5-10 years helping us, you're going to get more money.
They absolutely might say that. Other parents might not say that. They might say, okay, well, you know, we get calls from the other children, you know, twice a week.
Even though they don't live nearby.
Yeah, they go out of their way. They send their children to visit us, winters and in the summers. They invite us down to their home. They, you know, maybe pay for travel or facilitate travel. They host us. There can be a loving connection regardless of geographic distance. So the real question is, if we have a child, and this does happen, Leah sees it in her practice, but do we have a child who is preventing contact from the other children getting through to mom and dad?
So they're the gatekeeper.
They're the gatekeeper, and they've made decisions about which phone calls they might put through, or a letter arrives from the grandchildren, and maybe it doesn't arrive on mom's desk or mom's bedside. So there can be situations where the apparent wishes of a will maker are not, in fact, what would have been, but for the undue influence. Now, WESA, you hear it come up as an issue because before WESA, if I accuse you of unduly influencing a will maker, I had to prove that it had happened. Under WESA, we've reversed the onus, and it's no longer innocent until proven guilty. If you had the opportunity and if you benefited from the change in the estate plan and I accuse you, you actually have to prove that it wasn't undue influence that caused the change in the estate plan that brought you that additional benefit.
So you were closest to mom and dad, and look at the will, you're getting the lion's share of the estate. So you say, well, why is that? Can you prove? So how do you lay the groundwork to prove that?
So it depends on a lot of the circumstances, but the burden of proof shifting under WESA has been a big change for litigation. You still have to prove that there was coercion. And so one of the examples I often will give people is that if there is an elderly parent living at home, and maybe one of their children lives there, and like Alyssa was mentioning, they're isolating that parent by preventing other children or family members or even friends from coming and visiting that party, or they've said things to their parent like, you can continue living at home as long as I'm here if you give me this gift in the will.
Right.
If you do not give me this gift, then I'm going to make you move into an assisted living facility. That's the sort of simplest way of breaking it down in terms of a scenario where the court might say, no, you know, that will is invalid because of this undue influence, that will maker didn't actually intend to do that. They just felt they had no choice but to make that gift.
So what can you do on the planning side then?
Well, on the planning side, my staff, when they receive calls from clients who want to come in, they're very careful to take notes. Who made that booking call? Who was it? The child? Was it the client themselves? If the child is driving mom and dad to and from appointments, that in and of itself isn't suspicious. That typically will be the case for elderly clients. But if they're bringing the parent to a lawyer or a notary that they have a relationship with, that mom or dad didn't actually want to go to, if they're driving the circumstance that sets us up for the meeting, then we're very concerned about it. So we'll take notes, and we won't necessarily evaluate what's good or bad. We just want to know what the circumstances were so that later we can evaluate with the client and say, it looks like all of your children have been equally involved, so we don't need any extra documents, or I'm not concerned.
Do you have the child come with the parent to the office? Do you segregate them at some point and say, are you here on your own? Are you willing to be here?
Well, it's great that we're actually located in the tower above a shopping mall, because I can I can usually send those children off to do something productive. They might have to run to the drugstore anyway. They might want to grab a coffee. But yes, we absolutely meet with our clients in private. We want to know what their instructions are without the presence, which can in and of itself be an influence.
Have you ever had any enlightening interviews like that? Like, I don't really want to be here?
Absolutely. Absolutely. Clients will say, I don't want my son to or my daughter to get a copy of this will. I'm not going to do what they think I'm here to do. And then the question is, well, do you actually need a document produced? Are you happy with the document you have? Can we review that plan? We're not in the business of generating documents for fees when they're not necessary, and we don't want to participate in a farce with a client either. So we want to protect the client from either spending too much on a plan they don't need, going down a planning path they don't want, but also from the fear of retribution from a child that is deeply involved in their daily care.
So that's sort of abuse at some point, isn't it? So, on the family law side, you have spouses that are getting separated and they're withholding money from somebody, and that's a form of abuse, right? So when you have children looking after elderly parents who maybe don't have the strength and the willpower they used to, what do you do in those situations?
Well, there's a government organization called the Public Guardian and Trustee, and if we do get calls from people saying, I suspect that my sibling or this family member is doing this to our parent or family member, we will recommend that they contact the Public Guardian and Trustee, because they have the ability to investigate things that, as a litigator or just an estate planning lawyer, we can't do that. And so they will look into matters to a certain extent to determine whether there is elder abuse going on. And then there also is contacting the RCMP. But unfortunately, there's a limit to what those organizations can do,
and the amount of time they can allocate to it, right?
And so sometimes it ends up just being in an estate litigator's hands, where we're looking at the estate planner's file to see what occurred, who was making those appointments, who attended the appointments. So definitely having that in your mind is important.
So when you flip this on its head and it's innocent until proven guilty, and now you have to prove that you didn't exert some influence, how do you paper that? Like, how do you do that?
Well, a lot of it is contained in the estate planning file. So if we see that mom or dad called up this lawyer that they've been using for their entire life, and they decided that they wanted to give this gift to this child who has been providing them with this care, and then there was maybe a letter or a statutory declaration prepared by the estate planner at that time saying, this child has provided me with this amount of care, and I want to benefit them as a result of that. That's the reason I'm giving this gift. And that child had nothing to do with that, event or the contact with a lawyer. I mean, that's going to disprove undue influence.
Mm-hmm.
And we should say that it's not as common for us to find that a child who's helpfully bringing mom and dad in is, the bad guy, so to speak. We see children bringing parents in every day, and they're lovely. They're being very helpful. They're trying to facilitate mom and dad maintaining control over their assets, maintaining control over their plan, and being independent into those older years where they don't have the mobility that they used to. Sometimes when we're hard of hearing, it's just easier not to be the one that makes the phone call. So for those reasons, it's very common to see very helpful children with no untoward underpinnings and agenda assisting. And we're not suspicious when we see that, but we want to paper it because that's exactly what's going to help on the litigation side to defend the estate plan that we draft with the parent.
All right, in our last minute here, final thoughts on the subjects we've had today. Anybody listening to this show, this affects every single person, doesn't it? Right. So the power of attorney, everybody should have that, and maybe you can jump in the last minute here.
The power of attorney is often misunderstood, and we'll see people come in, pay for a power of attorney, and then either go to the bank and have their accounts jointured, which makes your children the co-owner, essentially, of the asset in some respects, as opposed to just registering the power of attorney. We see other assets jointured after the issuance of a power of attorney. And that's another question, was that an intended gift? Because obviously we already had the document that would have given them access to help us. So maybe that's evidence of a gift. There's a lot of misunderstanding about it. Everybody should have one, but we should also be educating ourselves about what it's used for, what supersedes it, and what it cannot be used for.
It's an onion that you pull back, and it's more and more layers. So that's why you need people who can really help you with that. Alyssa Lockhart, partner at McQuarrie Hunter, great resource, and Leah Donaldson, associate at McQuarrie Hunter, based in Surrey, but serving all of the greater Vancouver area. Thank you very much for your time. I appreciate it. Look forward to having you back. That's all the time we have for The Law Show. I'm Zach Spencer. We'll speak to you next time on CL 650.